All right. Hi, everyone. Welcome to the Riot Lunch and Learn series, the place where we spotlight Riot's sponsors and partners. My name is Natalie Ballard. I'm the Events and Operations Manager for Riot. Just a couple quick reminders before we get started. This event is being recorded and will be posted to Riot's YouTube channel and uploaded to the meetup page where you registered for the event. If you have any questions throughout the presentation, please place them in the chat. I will be monitoring the chat and we'll read questions aloud throughout the presentation. Questions are read aloud for those watching the presentation at a later date. Finally, please keep yourself muted throughout the event to help mitigate background noise. Today, we have Jesse Jones and Benjamin Jacob with Fourscore Business Law to discuss early stage startups, key issues, and legal strategies. Jesse and Benjamin, I'll turn it over to you.
Thanks, Natalie.
Thanks, Natalie.
It's good to be here. So I'll go ahead and make just a quick intro of myself, and then let Ben do the same thing, and then we'll kind of dive into what we're gonna talk about today. Hey, actually, Natalie, I forgot to ask you: is where are people from? Is everybody from all over the place, or mostly from Triangle, or what?
We've posted this in meetup pages in 6 different locations. So people are from Raleigh, from Charlotte, from Wilson, some folks from Virginia, from Atlanta, and all the way as far as Colorado.
Cool, awesome.
Nice.
Well, welcome everybody. I'm glad we could do this. It's been a little while since we've done a lunch and learn for Riot, but I think we've got a couple more on the calendar too over the course of the year, which should be good. So anyway, real quick, my name is Jesse Jones. I'm the founder and lead attorney at Fourscore Business Law. The firm's been around for about 5 years. I went to law school at Wake Forest, grew up outside of Philadelphia, so I'm still kind of bummed out a little bit about the Super Bowl. But I've been here in Raleigh for about 10.5 years now. And we work with a lot of entrepreneurs and business owners and founders of a lot of different types of tech companies, and we've been involved with Riot for a long time. So I'll kind of stop there. I'll tell you a little bit more about Fourscore as we get started on our presentation, but I'll let Ben kind of give himself a little intro as well.
Yes, thanks, Jesse. Hey, everybody. Great to be with you guys today. So I'm based out in California in Fourscore San Jose office. I joined the firm about 3 years ago. I was previously in-house at a startup out here in Mountain View, California, and then joined the firm. And I also, like Jesse, I'm a Philly, South Jersey native. And so also grieving that. I also spent some time in the Carolinas. We went to University of South Carolina. I saw someone in the chat from Aiken, South Carolina. So I'm a Gamecock fan as well. But very excited to be here and talk with you guys about startups and legal considerations.
Awesome. So we're going to sort of bounce it back and forth between Ben and I a couple of times throughout the presentation. If you have questions, feel free to put them in the chat. I like to sort of stop and talk about questions as they come up, just because I told Natalie I get bored of hearing myself talk for more than about 10 minutes at a time. So if you have questions about anything that we're talking about, please, please go ahead and throw those questions in, and Natalie will stop us if we don't see them. We can talk about them right then. Okay, so I'm going to dive in and kind of start us off here with just a couple of slides background, basically background on Fourscore. I wonder if I can get rid of this thing. Maybe not. Okay, that's fine. So real quick, just kind of what we're going to do today. We talk about Fourscore a little bit, tell you guys a little bit about who we are, what we do, type of experience that we have. We're going to go through some startup legal considerations, including some common pitfalls and a couple of specific things that we wanted to point out, and then we'll kind of wrap it up with a point, sort of taking a position or like a point of view as looking at legal as a strategy instead of a cost center. So that's kind of where we're going to go today. So first of all, at Fourscore, we like to say ideas deserve opportunity. And what that means is we really like to work with companies that are doing something innovative, whether that's intellectual property that they're building, or if they're doing something with they're putting together a new compensation plan for their team, or they're approaching the market a different way, or maybe it's an old company that's been around for a long time and it's been a service-based company and now the owners are trying to make it a productized company or something like that. But ideas deserve opportunity. That's kind of our tagline. That's where we kind of start our conversations from. So our basic, some of these 4 points here are, some of them are our core values, at least the last one is. But we like to simplify the complex, try to keep things as simple as we can. We try to communicate as clearly as possible, both in terms of what is expected and how much it's going to cost, how long it's going to take. We like to kind of act as an advisor, and sort of a long-term view is what we use when we're advising our clients. So we see the big picture and then don't be a suit. I like to think that we're maybe a little bit easier to work with or more fun to work with than some of the corporate firms that are our competitors. And that last one is one of our core values. So that's us sort of in a nutshell. In terms of what we actually do, it falls into 3 buckets. We do a lot of venture financing work, almost always on the company side, raising the money. We do a lot of mergers and acquisitions. We represent companies that we've had as clients for a long time. When they get to the end of the road and they're ready to exit, we also have clients that buy businesses to grow that way. And then we serve as outside general counsel for most of the clients that we represent. Almost without fail, our companies that are clients are small enough that they don't really need to have full-time lawyers on staff. And so depending on what the client does, we probably handle 70 to 90% of their legal needs. Some of the things that we don't do are patent applications and litigation. We're not tax attorneys, but we handle pretty much anything that's business legal related for our clients. Here's some resources, just a kind of a snapshot. Our website is chock full of resources that you can download for free or view. There's a lot of video content. We have an extensive blog at this point. We have a bunch of white papers that we've done on different topics, an ebook. So take a look at that at our website if you have any questions or you feel like you're looking for some more resources that could be useful. Okay, I'm going to turn it over to Ben. He's going to start off talking about some basic startup considerations and starting with why even create a company in the first place.
Okay, thanks, Jesse. So, this is seemingly maybe an obvious question, but it's worth thinking about, and maybe it's not so obvious. The first question, when you're getting, you're putting together a to-do list, you have a venture, you have an idea, and high on that list is going to be creating a company. And the reason why you need to create a company, some of these ones, again, might be obvious: limiting liability, making sure that there's no personal liability for yourself and for your founders as you start your venture and start engaging in trying to build out the venture. You want to make sure that you have protection against personal liability. The company that you create provides that. It gives you a shield, a liability that only extends to the company's assets. Secondly, perception. You've probably been there where you get an email from somebody and then you notice, that it's an @Gmail and not @Hotmail, and you wonder, are they legitimate or not? And that's a small example, but perception of once you formally organize the company and start operating with more formality, it signals to the people that you're interested in engaging, whether it's investors or potential employees, other potential co-founders, that you're serious and it's a real business and it's a real venture that they're talking to. And then lastly, there's tax benefits involved when you create the company. There's deductions, there's treatment of expenses that are more favorable when you have a company formed and organized. And some of this, gets into, we'll talk a little bit later, as, some of this might be obvious about why to create a company, but doing it the right way is really important. And part of what we do when we help a company get set up is making sure you're doing the little things that go into protecting your liability shield, forming a bank account, getting an EIN, making sure that you're basically setting the company up on a solid foundation so that you get all the protections that you should get as a whether it's an LLC or a corporation, whatever entity you've decided to form. I don't know if I think Jesse, you have control there. If you go to the next slide. So good segue into this next question. You've decided you definitely want to form a company. What type of company should I form? Where should I form it? The two most common forms for startups or businesses that are forming a new venture would be either a corporation or an LLC. If I know we have some people from all over, but oftentimes when we're talking with Riot, there's a consideration of, am I going to form an entity in North Carolina or Delaware? And it goes into, some of the considerations are around what you intend to do with the company. If you intend to raise outside capital, you're almost certainly going to need to be a Delaware C Corp. Investors are going to require that. We've often handled deals where as a step to get ready, to be ready to raise money from whether it's an angel investor or an institutional venture fund, they require whether it's a North Carolina LLC or some other jurisdiction, they require the company to convert into a Delaware C Corp. And there's a number of reasons for that. But there's definitely an investor preference for that state and that type of entity. Other businesses, an LLC can be a great option for you if you're not raising outside capital, provides flexibility, and just it's very simple to put together and draft an operating agreement that basically lets you do what you want with the business.
Hey Ben,
can I
ask a question that?
Please.
I don't see a question yet, but I am going to assume that somebody has this question. What if I start my company and I don't think I'm going to take outside capital and I set it up as an LLC and then later things change?
Yeah, great question. And this does happen a lot. So you can convert the entity. In most states, you'll be permitted to convert the entity. In North Carolina is a state where you could take that North Carolina LLC, convert it into, you've learned that you are going to be raising outside capital, you have a term sheet, you need to get it done. Fourscore, that's something we do frequently, is just helping a company convert the North Carolina LLC into a Delaware C Corp. And it's putting certain documents together to handle the filing with both states, but it's relatively painless to do.
Thanks. We actually do have a question now that I'm looking at here. I can read this out, and Ben, if you want to take it, you can, or I can answer it. This is from Eugene. Thanks, Eugene. With the changes in tax considerations, with NC being lower at 2.5%, why is Delaware still preferable? I'm happy to answer that just because I started my career practicing in Delaware and I have heard this spiel so many times. I could probably dream about it still. But so basically when you're talking about the advantages of Delaware, it really comes down to, there's two like real answers, and then there's a third answer that's actually might be the most practical, but just doesn't really make any sense. First of all, Delaware is a really small state. So for a very long time, the legislature there, I've lived in Delaware, it is a small state and people do really know who each other are. So the legislature is pretty tight with each other. They've got, close relationships. Frankly, half of them probably went to high school together. And so for a very long time, Delaware was the leader in corporate law because they were, number one, intending to do it. They knew that they could have an advantage over, at the time, New Jersey. This is all the way back, like in history, when DuPont was a New Jersey corporation, and Delaware basically was successful in recruiting DuPont to leave New Jersey and go to Delaware. And then that spurred on a period of time where the Delaware legislature just was at the forefront of corporate law. At this point, pretty much all the other states like almost copy Delaware corporate law. So the statutory piece is, for the most part, relatively similar in most states. But the second part is the Court of Chancery in Delaware, which is their business court. The Court of Chancery does not hear anything except for corporate cases. The judges do not hear criminal cases. They don't hear family cases. They don't hear anything but corporate cases. And the chancellor and vice chancellors are all 25 to 50-year veterans of corporate law, whether they're transactional attorneys or litigators. And so that has built those two things together really kind of over time built a situation where investors and people all over the country are very comfortable with using Delaware law because they want any type of dispute to be heard in that court. The third reason is because that's the way it's been done for the last 40 years, which is kind of a stupid reason, but there is a lot of, especially when it comes to like, private investing and venture capital and all that kind of stuff, there is a lot of, well, this is the way we did it before, so we're gonna do it again. And so that really is a big part of why Delaware gets chosen for all of these different technology companies and other types of businesses. Okay, we have one other question, and maybe this is something you already kind of answered then, but I'm going to kick it back to you. This is from Karan or Karen. I'm just starting out. I was thinking to use an LLC in Ohio. Should I spend resources to do it right from the beginning when I don't know about the future?
Yeah, I think that question, there's a number of factors that probably would go into, a complete full analysis and answer there, but most likely it's fine using an LLC in Ohio, especially if you don't have definitive plans to raise outside capital and you're just getting the venture going. And it's something that, again, we would need to check the laws in Ohio, but there would be a relatively painless way to convert. There should be. I'm not, Jesse, I don't know if you know about Ohio. I don't know off the top of my head if they have a statutory conversion.
I actually just looked at Ohio for another client, and most states, including Ohio, have like a reciprocal conversion statute with North Carolina, so it's pretty easy to do.
Okay. Yeah. So with that in mind, I think if you're just starting out and you're not really certain as to what the future holds for the business, there's not really a compelling reason to form a Delaware C Corp right away. I think you'd be in good shape, getting, again, that's with limited, understanding of what the business plan is, but an LLC in Ohio may be the right choice at this point in time. Okay.
I think I stopped you at the S Corp piece and we didn't get back to that. If you want to dive into that part.
Okay. Yeah. So the S Corp, the last thing to say on this in terms of entity types, there's also the ability to make an S Corp election that provides and allows the entity to have flow through taxation, meaning you're not having double taxation at the entity level and the individual taxpayer level. For an LLC, the owners would be considered an employee. That may limit taxes for Medicare or Social Security taxes. The procedure requirements, you have to actually file the form 2553 to make the S election. Restrictions, if you're going to make the S Corp election, you can only have one class of stock. You can't have a Class A and a Class B. You have to have one uniform class of stock with the same economic rights. And then there's also a cap on the number of stockholders. You can have 100 stockholders maximum for the entity. And again, lastly, you see the third bullet point, only U.S. human shareholders can be on your cap table if you're going to make the S Corp election. Anything otherwise would require that the tax election to be changed.
What's a non-human shareholder then?
A non-human shareholder, LLC, corporation, maybe that Ohio LLC.
Also, probably can't use your dog or cat as a shareholder on that.
That's right.
Ben and Jesse, we've got a question from Sarah. She said, what are the most relevant differences between an S Corp, C Corp, and LLC? And just kind of the benefits of the different ones.
Am I on mute now? No, okay. So really the differences are tax differences, and we can kind of give you the very basics, but we're not CPAs. So C Corps are entities that are they pay income tax themselves. So if you have a C Corp entity, then when that company has profit, it will pay income tax and file its own income tax return. And then if there's profit, that will be distributed out to the stockholders, and they will pay taxes on the distributions. An S Corp and an LLC taxes an S Corp, or an LLC taxes a partnership, or a corporation taxes an S Corp. You kind of can do a bunch of different things there. Those are S Corps and partnerships are both flow through. So the entity itself does not pay its own income tax. So if it's an LLC or an S Corp, and the company's profitable, the profits are allocated out to the owners, and the owners are going to pay the taxes on whatever they're allocated of the profit. So that can be useful both ways. If you are making money, it can be useful to have a flow through tax model where it only gets taxed one time. It can also be useful if, and this is where you really have to talk to your CPA, but if you're losing money and it's a flow through, there may be an opportunity to offset income from other sources from the losses that you sustain through an S Corp or an LLC. Whereas if it's a C Corp, all those losses get kind of trapped there and can only be used later on if the C Corp makes money. Anything to add, Ben?
No, I think that that hits. Oh, sorry, I was just looking at Scott's question, but yeah, no, I nothing to add there. I think that hits it pretty well.
Yeah, you want to address Scott's question there?
Yeah, so I think that might be a reference to. So I'm just reading this, making sure I'm reading it carefully. So.
Yeah, I'm actually going to read it out loud just for the people that are
Sure.
watching the recording later. Scott asks, aren't LLCs considered people in some states like Montana, which can own property? Could that LLC be a shareholder of S Corp stock?
Yeah, so I mean, an LLC can hold property, own property, in I believe every jurisdiction. That phrasing that aren't LLCs considered people, that was reminding me of the Supreme Court case, Citizens United. I'm wondering if that's what Scott was thinking of as far as the ability to make political contributions to different campaigns with that notion. But an LLC can definitely own property, and is actually a common corporate structure to hold real estate is using an LLC.
Yeah, it also, like an LLC can be a stockholder of a corporation that's taxed as a C Corp, and it can be a member of another LLC. But if the company is taxed as an S Corp, its stockholders have to be individual people, like human being people. There are some very narrow exceptions to that for some trusts. And maybe, it depends on what CPA you talk to, maybe a single member LLC, where it is also a flow through, but most CPAs I've talked to about that say no. That actually goes into the next question from Karan. Would it be okay to create an LLC by myself? I'm asking this because I am the only founder of my company, and the filing process for LLC seems pretty easy. Yes, that's completely fine. You don't have to have more than one person. There's a question from Sergey about IP and non-tangible asset transfer. We're actually going to talk about IP in a little bit, so I'm going to hold off on that one. And then Chip is asking a question about protections provided to shareholders. What are the most seen issues that officers might forget that aren't covered by these protections? So the first thing that comes to my mind, Ben, you can hop in on this if you want to. If you are a director, like on the board of a company, you're going to have fiduciary duties. And although you are very protected against, things going badly and shareholders just being upset because, the company didn't survive or didn't, do as well as they thought. That's called a business judgment rule. That's basically the assumption that courts apply to cases where directors of companies get sued And it's really hard to overcome that. It's a presumption in favor of the directors, basically saying, look, nobody knows the future. If they do what they're supposed to do and they make a decision and it turns out that it was a stupid thing to do, they're not going to be held responsible for that. Because otherwise, who would sign up to be a director? And it would be really hard to get, keep the economy going. But there are fiduciary duties, duty of loyalty and the duty of care. The duty of care is essentially like the responsibility to be aware of what's going on and to attend board meetings and be prepared for them and read documentation that you're asked to read and provide your thoughts. The duty of quick care actually can be restricted in some cases through contract to give the director even more protection. The duty of loyalty is basically prohibition against self-dealing or taking action that would benefit the director at the expense of the company that they're a director of. That cannot be limited. And so if there's a director on the board of a company and starts taking action that harms the value, the shareholder value, that's done, which is it's helpful for him, but it hurts the company he's a director of, and that's going to be something that you need to be very aware of. I'm gonna skip over that because we've got a bunch more slides to go. Let me see here. IP. Yeah, we'll get to IP. Okay. Sorry, go ahead,
Okay.
Ben.
Yeah, and the one thing I was just going back to Karan's question about forming the LLC. Yeah, I think you're asking, one, you're the sole founder of the company. The filing process for the LLC seems easy. And I think Jesse's answer was yes. The only thing I was going to add is, the process can be easy as long as you're making sure. There's a number of providers that do a pretty good job when you're wanting to form an entity and online services that'll help you do that. It's just very important to make sure you get all the inputs correctly, everything that you need to provide. Wanting to make sure you understand what they're asking for, and then making sure that's accurate, because that's usually we've seen a number of companies that have been successful using those types of services, but probably the same amount or more that they run into issues because of the inputs that they provide, leading to some of the governance docs not being accurate or making sense. So just wanted to add on to that. Jumping back in here under startup considerations. So talking about the entity type, and this also goes to Karan's original question about what type of company should I form. You're thinking about what is the long-term picture and plan for the company. What's the goal? Is there an objective around an exit, hoping to sell the company, or are you planning to be the day-to-day operator for the foreseeable future? Is an important one. And that ties into your capital raising strategy. Will you compensate others with equity? Going back into the LLC versus C Corp question, usually when a company intends to raise outside capital, but also if they're planning to compensate a lot of their service providers, employees, contractors with equity, that's another reason that a C Corp can be a lot simpler, because you can set up a stock plan. It becomes much easier to manage and process administratively. It's probably not determinative necessarily, but it's one of the things when we're working with a client that's set up as an LLC, it can get complicated as they try to think through how to compensate people with equity. It's doable, but it can be a lot easier with the C Corp. Again, what we've talked about, do you plan for the entity to pursue outside investment to capitalize the business? Thinking through your tax strategy with the tax advisor, your CPA, and then flexibility. That kind of rolls in a lot of the consideration we've talked about. An LLC is probably the most flexible business structure you could form, and allows you to do a lot. And just in terms of what you document in the operating agreement, you can basically customize the business, its governing rules to do and be whatever you'd like it to be within the law. So there's a lot of flexibility in an LLC. Okay, so again, as we move through this, we've talked about, why form a company, what are the considerations that goes into which entity to select. Next on the list, as far as important critical startup considerations, is getting organized, as far as who owns what, who does what. These are things that are often can be left kind of kicked down the road because there's so much going on, but not paying proper attention to some of these key issues can end up sinking a business before it gets off the ground. We've seen that. So number one, with your founders, your founding team, having a conversation that's clear and makes clear to everyone who owns what. What is the equity split going to be amongst the founders? Sometimes that's really easy; it's an equal split. But sometimes the contributions and the value brought by each founder justifies, a different type of split, and it's an important conversation that you don't want to avoid. And just you want to have that up front. Other items here, founder vesting. Some founders, are like, they want to be fully vested up front, which is logical in a way, but knowing that your future investors are going to want founders to have their shares, their stocks subject to vesting is important to understand. And it usually makes sense to just put vesting in place up front. We're going to talk a little bit more about 83B elections, what they are and why it's critical. But that's something that almost always is going to make sense for founders to do, to make that election for tax purposes. Thinking through employer and contractor equity. How are you going to compensate? Presumably cash is going to be tight. How are you going to incentivize and attract talent to the business? Figuring out what management roles are going to be divvied up and who's going to sit in what seat. And the last two, thinking about the organizational decision-making structure. If you're a corporation, you're going to have a board of directors, an LLC. It's either going to be member run or manager run. Oftentimes, the managers are the members for a new company. And thinking about what are the key decision points that, and what thresholds. Is it going to be majority threshold? Is it going to be unanimous consent that's going to be required for certain decisions? Those are things that, will get baked into the governing docs, the operating agreement for an LLC. But those are things that need to be thought about. And again, this is where having, good counsel to guide through the process is important. And lastly on that list is, some companies choose to form a board of advisors, which can be a strategic advantage in bringing in knowledge experts, domain experts to come in and help the company as it gets off the ground. And very quickly here, you just see on the left-hand side, the organizational documents for a corporation. On the right-hand side, organizational docs for a limited liability company. Gives you a general sense of what documents need to be in place depending on which entity you've selected. And lastly, this ties in on this section with a couple of the questions. Considerations around protecting your ideas. So intellectual property is at the core of this point. Are there people that need to assign IP? Are there, whether it's a contractor, whether it's a founder, works for hire arrangements, maybe you've outsourced development. Does anyone need to assign IP? NDAs, usually if you're pitching, pitching investors on investing in the company, they're almost certainly not going to sign an NDA. But as you start engaging with vendors and potential partners or customers, having a solid NDA in place is important and will help protect the company's confidential information. Filing for IP protection, if there's patents, trademarks, other pieces of intellectual property that can be protected, that is going to be critical and important to the business to handle and get engaged. If that is going to be the case, there's going to be filings that need to be done, making sure you have good IP counsel guiding you along the way and getting those filings completed. And this last one, non-compete, non-solicit, and confidentiality agreements. ties in a little bit with an NDA and how do you assign. Typically you're going to have a standard doc that you put in place that helps cover all these. We usually there's different names for it, but a proprietary information inventions agreement. It covers your restrictive covenants on non-compete and non-solicitation, but it's also where the individual signing, it could be a founder, could be an early employee, could be a contractor. They sign and they're essentially agreeing that everything that they've done as part of their service or engagement with the company belongs to the company, and they're taking, and that's a very brief high level view of it, but having a PIA signed and executed is going to be really important for everyone involved in the business.
We had a request to go back one slide, so I'm going to just slide back in here. And then there was a question. If you are starting, I guess it's from Jennifer, thank you. If you are starting two businesses not related, does it make sense to form a holding company? Can you explain the pros and cons? Ben, you want to give that a swing, and then I can add anything?
Yeah, sure. Yeah, so if you're having, you're starting two businesses, there may be advantages to forming a holding company organizationally, making it things simpler and kind of putting everything under one umbrella. The main con is if you wanted to make sure that you kept those assets separate. If you're having, investment into one entity, whereas the other business is a consulting, as long as there's clear separation, you're probably okay. But as far as the holding company, making sure that there's not overlap in the business and in the formalities is definitely going to be important, especially if you have, investment or other, critical considerations with one entity versus the other.
That's great. One other question that came in, Greg K, are non-competes still legal? So I'll give you my perspective, and Ben's in California, so he's got a totally different answer. But for the most part, up until now anyway, non-competes are matters of state law, they're contracts. And so while most states have been moving more and more to saying that in an employment context, non-competes really should be extremely narrow or just not enforceable at all. For the most part, they are still, we can't say that they're not enforceable or that they are illegal, because if they're drafted the right way, in most cases they are still enforceable. There was a headline I saw from a month or two ago where there is some push at the federal level to maybe make them just not enforceable at all. Maybe that'll happen, maybe it won't. But one instance where they really do make sense is in an M&A context. So most of the time, the seller of a business is going to sign up for a much longer and probably more, aggressive non-compete than somebody that's in an employment context would. Ben, you want to give your California perspective?
Yeah, in the state of California, non-competes are not enforceable across the board. And so it's a very aggressive state in protecting workers' rights. And so as a matter of public policy, the Supreme Court, I forget what year that was, but for some time now, you can't enforce a non-compete in the state.
And that can get kind of confusing when you are not a California company, but you have employees in California, because under your state law, it would be okay, presumably, but it probably actually is not, because usually the location of the employee, has some leverage over what law applies. Mark, hey Mark, can you set up nonprofits? What is necessary to do that? We can set up nonprofits. It's very similar to setting up any other kind of company. Actually going through and getting tax exempt status is a different story. That's not something we really have a whole lot of experience with, but yeah, we can help get nonprofit entities set up. All right, we are going to move into some pitfalls. Before we dive into this, so are non-competes enforceable if you work for a company in Boston but you live in Virginia? So that's a good example. I don't know the answer. We'd have to look at the contracts, we'd have to look at the state law, figure out what law applies, and then then you'd have probably a better answer than I don't know. But it can get confusing because these days especially companies have employees all over the country, and different states treat them differently. Okay, I'm going to take on potential pitfalls, and I'm going to give us I'm going to take just 5 minutes at the most to kind of get through this because we have a couple things we want to talk about at the end too. So here are some of the common things that happen to early stage companies. And then Ben, if you want to keep an eye on the questions or whatever, you can just interrupt me if you want. Okay, so founder disputes, it's unfortunate, but not uncommon. Obviously you would not go into business with, or hopefully it's obvious, you would not go into business with someone you didn't trust. But things change, people change, that's why we have contracts. So if you're not clear about who owns what, it probably won't matter until the company is more valuable than it is today, and then it's going to be a pain in the neck. What happens if you want to get out or you need to get a partner out of the business? That's something that is addressed much more commonly in operating agreements for LLCs, because LLCs tend to be businesses that are going to be run over a number of years, where a corporation, a technology company, is probably something that the ownership is going to be changing very often, bringing new investors in, bringing employees in, giving them equity grants, all that kind of stuff. But it's really important to think about those things. When you're hiring people and you're bringing contractors on to help in an early stage, one of the things that we've run into a couple of times is a very early stage company. You have 2 or 3 founders. One guy's a CEO, one guy's a CFO, and one guy's a CTO. And that might be great, but often that can cause problems because 2 years down the road, the guy who is the quote CTO or the CFO or the CEO, whatever, really doesn't have the experience or the chops to be the CTO. And so now you have a weird situation where your founder CTO, you need to hire a real CTO, because the guy that started out is really good at what he does, but he's not equipped yet to be an actual CTO, and then that's kind of an awkward situation. So when you're hiring people, even with the founding team, you want to consider, just be careful about the titles you get. Titles, a lot of people think titles don't matter, but they do matter to some people. IP issues, that is a huge potential pitfall, because if the documentation, like Ben was talking about, is not clean, it's not clear that the company actually owns the IP that it needs to run the business that you're trying to build, it's going to be very, very hard to get investors to put their money in. It will be impossible to get somebody to buy the company if that's the goal, because it doesn't even own what it needs. And like I said earlier, it's just so much easier to clean up all those IP issues and transfer what needs to be transferred at the beginning, because once there's real money involved and there's been some success, everything kind of changes. Distinction between employees and independent contractors is still an issue. It's been an issue for a long time. Business owners and companies want to categorize all of their workers as independent contractors in most cases because it's cheaper. You don't have withholding to take care of. You don't have to cover benefits. It's just easier to kind of get started with independent contractors. But you can't just call somebody an independent contractor and have it be so. There's a sort of a facts and circumstances test that loosely, kind of goes around the amount of autonomy and control the worker has over the work that they do. If you're telling them they have to be in your office from 9 to 5 and use only the computer you hand them, it becomes a lot harder to call them an independent contractor because they look a heck of a lot like an employee. So that's important. That has caused problems for for clients of ours that had miscategorized workers, and you just don't want to deal with that. It's a huge distraction from trying to build a business. At some point, when it's 2 or 3 people, maybe it doesn't matter as much, but things grow quickly. And if you've got 10, 15, 20 employees, the lack of written employment policies can be a huge downfall. So that's important to kind of keep up on. And then termination of employees, equity vesting, making sure the vesting schedules actually work, and non-competes, which we've already talked about. Vesting, I'll talk about just real quickly. It is the simplest, best way to protect the company and the founders against some other founder leaving with a huge chunk of the company, which makes it extremely difficult to fund it in the future. Vesting is a good thing. All right, skipping on intellectual property, just kind of circling back on that. Not only is it important to make sure that the IP that's being created for the company actually is owned by the company, but as you are hiring people in, it can be a pain in the neck to keep track of who is, sorry, my timer just went off for myself. I'll move a little bit quicker. It's possible that you could be violating somebody else's IP rights because you hired somebody who brought something with them that they shouldn't have. So usually a contractor agreement, an employment agreement is going to have some kind of representation from the worker saying that they have not taken anything that doesn't belong to them. I'm going to skip across some of this stuff because I really want to get to 83Bs. But real quick, there was a question I saw about the holding company question, which is what Ben answered. It's just really important that whatever you do, if you've got more than one company, you need to have more than one EIN, you need to have more than one bank account, you need to have, basically, you need to treat them as if they are separate. Otherwise, you run the risk of them being combined when there's a problem. And you don't want the assets and liability, or you don't want the assets of one company at risk for the liabilities of a company that has absolutely nothing to do with that. So it's very important to kind of keep to the corporate formalities, make sure that you treat them separately so that everybody else will treat them separately.
And Jesse, there's one other question related to IP from Sarah, and I think she might have asked something similar to this about transfer of physical assets and non-physical ones to a new company.
Oh yeah, I see it. How do you transfer physical assets and IP assets to a new company? So, I mean, basically you can assign it or sell it. Essentially, there's going to be some kind of agreement between the owner of the asset, whatever it is, and the the entity that you want to have ownership over that. And so, from a contract standpoint, there's going to be some kind of agreement between those two. If it is a IP asset that's like a patent, or it's got some other kind of like formal protection, there may also be, like for a patent or a trademark, for example, there is going to be a process where there is a transfer recorded on the Federal Register or whatever register there is. Hopefully that answers the question. I'm going to skip forward.
Yep.
A couple other pitfalls. I'm just going to go right to this 83B thing because we are running out of time, and this is a big deal. So in 83B, just to give a very quick primer, and there's a great article, there's actually a couple articles on our blog about 83Bs. But essentially, if you start a company and you're issued shares as a founder, they are probably going to be subject to vesting. The way that the tax rules work, the value of those shares is not taxable to the recipient of those shares until the shares are vested and they are no longer at risk of forfeiture, which seems like a good thing, at first glance, because why would you want to pay taxes on the value of something that you might not get to keep? The problem with that, though, is that, especially with technology companies, the potential for them to increase in value significantly over a short period of time is, better than a landscaping company or something like that. And so if you don't file an 83B, the default is what I just described. If you do file an 83B, then the way that you get taxed is you will pay taxes on the value of the shares when they are granted all at once. And that is better because 4 years from now, when your vesting schedule is done, your company could be worth 100 times or more what it's currently valued at when you haven't really done anything yet. And so in almost every situation, founders want to file that 83B when they receive their shares. There are very strict rules around these 83B forms. They have to be filed within 30 days of receipt. Well, it's really 30 days within the imposition of that risk of forfeiture, but usually that happens at the same time the shares are granted. So you have basically 30 days from the time your shares are issued to file this. If you do not do it, for the most part, it's too bad. It's too late. There's no way to do it electronically, so you have to get a stamp and you have to send it in duplicate with a return address already stamped so that you can get a, proof that you actually did file this. It can cause massive tax problems in the future. We had a client recently where this happened to them, and the two founders, between the two of them, originally were going to owe more than $500,000 in taxes in order to get the deal done with the investor, because the investor was all bent out of shape about the fact that they couldn't find any fees. It can be a huge mess. It's also important to the company, because if the shares are subject to vesting and there's no 83B filed, then the employee or the person receiving the shares is going to have to pay taxes as they go, and the company probably has withholding obligations. So if the company goes 4 years without withholding the value of the shares that are vesting over that 4-year period, the company's going to end up with a huge tax bill and penalty. And that's also a problem when it comes to the next investor or acquirer or whatever. And that's kind of the last bullet point there, leverage point. Investors and acquirers are looking for every single thing they can use to apply leverage to reduce the price or get some other kind of concession. So this is an easy one to deal with at the front end, but it's got to be dealt with at the front end. And then, is failure to file fixable? I don't have time to get into it. You're gonna have to read the article that Sean Valley on our team wrote that was just published a couple of weeks ago. It's great. So take a look at that if you have questions. And then with that, I'm gonna knock it over to Ben for our last topic.
Okay, so our last piece here we want to talk about is how to use your lawyer effectively, and really how, as a company, as a startup, to think about legal. And at Fourscore, we're advocates of treating your legal strategy as a dimension, as a key component of your overall business strategy. Oftentimes we run into inexperienced teams that really try to do the bare minimum on the legal front, which it's not illogical. You're managing precious resources, and if it's not essential, then you make the argument that it's okay to hold off, and sometimes that is okay. But really we try to advocate for the right mindset. So starting with this first slide here, using your lawyer effectively, you should think of your lawyer as a member of your team. In terms of your day-to-day or whatever it is, your interactions with your lawyer, it's very helpful and will save you time and money. Giving the whole picture, asking and formulating specific questions, that'll definitely help, making sure you're getting what you need as efficiently as possible. Understanding payment structure and options that are available to you. And the one above that, giving your lawyer adequate time for thought, so that your counsel can think through the situation and come up with recommendations that are precisely tailored. And going into the next slide, thinking of legal as a strategy, we started talking more and more about that. And with the macroeconomic conditions, it's probably never been more, well, I wouldn't say never. It's become much more important now for startups to control their spend, especially as they seek to raise more capital. If they've already had investors invest and they're looking for their next round of funding, there's a pressure to control cash burn. And for startups that are just getting started, there's an opportunity, thinking through your legal strategy, as I mentioned before, as a key part of your overall business strategy. And so the starting process there, identifying the right law firm and the right law firm relationship that's going to partner with you. We talked a little bit about, there are a number of really good tools out there that can help you incorporate a company and get you set up to do some of these procedural things that are important. But there's now a more automated way to do it. The danger there is believing that you won't need counsel when you get into more sophisticated and complex situations, as you negotiate deals, as you get a term sheet, as investors start to kind of kick the tires on your company and where you are. that's not the point in time that you want to be looking for your lawyer. We would strongly advocate, talking, getting recommendations, finding a law firm that you can partner with. It doesn't mean that, all 10 recommendations that they tell you need to do ASAP that you need to do, but getting that relationship in place up front is important. We strongly believe a well-designed legal strategy, it's going to help you grow, and it's going to reduce risk that would otherwise be there. And growing the right way with sound contracts that are well thought out and really position the business for success. You can go to the next slide, we can finish up. So we would, thinking about legal as a strategy, starting with assessing your corporate governance, your law firm should be able to help you do that, taking a look at all of your documents and then spotlighting issues and then tell you, we think this is something you have to fix now, or, there might be a time period where, we think you might have some time to do it, but you should lean on your law firm, your counsel to say, this is everything I have. What do I need to do to have everything in order is the first step, having that assessment done. And secondly, investing in developing strong core business documents. We've talked about some of these, but a solid NDA, your customer contract that you're going to be using, vendor agreements, all of your employment documents, whether it's for employees, contractors. You want to make sure those are sound. We've talked about IP, the work, if you're engaging contractors, you want to make sure there's a solid work for hire provision in there that makes your future investors feel very good and comfortable that you guys have, documented everything appropriately for the business, and IP is well protected. And lastly, preparing, you're preparing for, especially if you're a startup that does intend to seek outside capital, you should be thinking today, I need to be prepared for that time when I'm going to be ready to raise. Even if that's way down the line, you want to be ready as possible, or at least have a clear line of sight. This is what we need to do to be ready. And these are the steps. And I know we're running short on time, so I'm kind of flying through that so we could leave some time for questions, but I'll stop there, and then maybe we could turn to some questions.
Yeah, that's great. There was a question specifically about 83Bs. Eugene, if someone is granted option and files the 83B, but leaves and has to give up the shares on which they have paid taxes, is there any refund? Short answer, no. That is a difficult position for somebody receiving equity to be in, because you have to decide, is this worth it or not now? However, in most cases, if you are issued options as opposed to actual shares of common stock, you will not need to file an 83B if you receive options. Now, if you early exercise your options, or there's something else going on, that may be different. But if you just receive options and you're just going to kind of wait and see what happens before you exercise, you don't have to decide that when you are issued the options. So if you're actually given shares and you file an 83B and you pay the taxes, that's it. There's no way to get that money back if you actually don't vest in the shares. It's an unfortunate situation, but that's the way it works. We got like 1 minute, I think. If there's any other questions, let us know. And if you've got other questions, Natalie can, I'm sure, find us and send your questions along later.
Yes, definitely. I see your emails here, so that's a great way for people to connect with you. But thank you for a wonderful presentation, Ben and Jesse. This was awesome. As a reminder, Riot hosts Lunch and Learns weekly on Wednesdays at 1 p.m. You can find our Lunch and Learns on our meetups where you registered for the event. This event was recorded and will be posted to Riot's YouTube channel and the meetup page where you registered for the event. Thank you all for joining today. I hope everyone has a great rest of their day.
Thanks, Natalie. Thanks, everybody.
Thanks, Natalie. Thank you, everyone.
Thank you.